Conclusion that Congress can turn the right to birthright citizenship on and off in U.S. territories is a disturbing one that runs counter to the clear text and history of the Constitution itself.
Former Guam resident and civil rights attorney Neil Weir is referring to a federal judge's decision concluding that citizenship is not guaranteed to people born in unincorporated territories. The decision was made in Washington, D.C. District Court in the federal case of Tuaua V United States, where 5 individuals born in the American Samoa were fighting their claim that the Constitution guarantees people born in U.S. territories the right to U.S. citizenship by birth. Weir is the lead counsel on the case. Weir says federal law currently labels these individuals with a subordinate status of non-citizen nationals, a status similar to people born in Guam prior to the Organic Act.
As a result, they're treated differently than other Americans. If they move to the States, they can't vote, they can't obtain certain jobs, and face other restrictions that they wouldn't have if they were recognized as citizens like everyone else.
So what does this mean here at home?
What it means for Guam is, under the judge's logic, Congress tomorrow could change federal statute and henceforward people in Guam could not be recognized as citizens. And that's the kind of power that the 14th Amendment was meant to take away from Congress.
Former Senator Hope Cristobal, meanwhile, says she always understood that citizenship was statutorily granted by Congress.
Remember, the whole government of Guam was created by Congress, and we knew that it was penned in citizenship, and just as quickly they can unpen it or erase it.
She says the issue really should be more about equity rather than equality, adding it would take a major act of Congress for this to happen.
And I would imagine that there will be an uproar, and when that time comes, we will be ready to stand up to that kind of an action, an adverse action by Congress.
Weir, meanwhile, says this is only the beginning of the legal process, adding in these types of complicated constitutional cases. The decision is ultimately decided on appeal, something he'll be taking up.
But there'll be more opportunities on appeal to present these clear constitutional arguments to the circuit court, and we look forward to having those arguments at that point.
Weir adds the judge in the ruling had the opportunity to turn the pages on the insular cases, but instead relied on them for his decision. Vice Speaker B.J. Cruz, meanwhile, says he's disappointed in the district court, saying this provides Weir the opportunity to take it up on appeal, as he believes the U.S. Supreme Court needs to address this and correct the, quote, racist decisions, end quote, that were issued in the 1920s with the insular cases. He adds the insular cases are, quote, insulting and needs to just be put to bed completely once and for all, end quote. Reporting for Guam's News Network, I'm Ken Quintanilla.